Can you respond, Mr. Chair?
As the court pleases, my lord. I think it's crucial to distinguish between two concepts. The first one is relevance, and the second one is the weight to be attached to the evidence. And I think what my colleagues have put emphasis on is the weight to be attached to the evidence. But the first hurdle, my lord, is relevance. Evidence can only be admitted if it's relevant. And at this point in time, the question is whether is the evidence relevant? And we submit, my lord, that it is relevant. The court has previously referred to Section 210 of the Criminal Procedure Act, which reads that no evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point of fact in issue in criminal proceedings. Now, we have argued in the past, my lord, that we have facts that are in issue, and the Latin term that is sometimes used is the facta probandum. And you have facta probantia. You know, those are the facts that you use to prove the facts that are in dispute. Now, you can only lead a fact to prove a fact that is in dispute if that fact is relevant. And we submit, my lord, that the evidence is relevant. And I want to deal with the submission of Mr. Ramsipili that this is Section 3 of the Hearsay Evidence Act is not applicable. And I think that aspect was also touched upon by Mr. Numalo. My lord, the fact is this, you can have real evidence, which is the footage itself, but if you want to prove the contents of that footage, that becomes documentary evidence. And I think that is where my learned friends, with the greatest of respect, miss the point. And once you want to prove the contents of a real exhibit, as I indicated, that becomes documentary evidence. And you can only prove documentary evidence through three means: by calling the author. Well, firstly, the documentary evidence must be relevant. And secondly, you must call the author to prove the contents thereof. And thirdly, you must prove the authenticity of that documentary evidence. And that is precisely, my lord, what the state seeks to do. The court will remember in the olden days when there were illegal gatherings were prohibited. Tape recording is made of the proceedings. Someone would come, a policeman will always come and say, the video will be played, and they'll come and say, so and so on that video, it's accused so and so, and the person on the video is accused so and so, you know. That is when you prove the contents of real evidence. Sorry. Mr. Numalo questioned us why the state took long to present the evidence. We have, on the previous occasion, my lord, indicated that there's a certain procedure that you must follow if you want to tender evidence from media houses. We indicated, my lord, that there's an agreement between South African National Editors Forum and the law enforcement agencies that you have to follow a certain process if you issue a subpoena. And we did indicate in this court, my lord, that we started this process as far back as December 2024 in securing the subpoena, because the subpoena must be authorized by the National Director of Public Prosecutions, and thereafter the matter then goes to a local magistrate in Boksburg, and a subpoena is then issued. That is the route that we followed in the current instance.
Advocate Baloyi just confessed, or should I say just confirmed, to playing games when it comes to the submissions that Ungomezulu, the propositions that Ungomezulu made on the 28th of August 2024. Let's do a timeline recap, okay? So from September, October, November, and we all know what happened in December. So Advocate Baloyi and the prosecutorial Ndondoni only initiated the request for that video in December. Why in December? I bet you it was after December 10th. I bet you that. I bet you that's when they did it, because now they knew they wouldn't face any resistance on that video. Because Ngomezulu, remember, in his utterances, and again, I will insert the video here. In his utterances, he said, I have a witness. Now, Ngomezulu has passed away. Just like the Makelenis and all the others who have passed away with their evidence. But Ngomezulu has passed away with critical, crucial evidence. The evidence that places Longwe Twala behind the trigger. The evidence that shows that Longwe Twala had a bullet in Dondon, okay? Now that Ngomezulu had passed away, and I'm really sorry to bring this point up, but unfortunately it ties around Ngomezulu. May his soul rest in peace. So here's the thing. Sneaky Baloyi, at that moment, as he passed away, everybody is in mourning. The nation is in mourning. Baloyi, they went through recess during that time, remember? And that is the time that he places a subpoena request to go through the magistrate, to subpoena the South African and editors in Dondoni, and you know what? And he says, we have to follow procedure, we have to follow protocol, we've got to do things this way. It took you 4 months from August 28th. All this time, it took you all this time to submit that subpoena. You would think it's a matter of urgency, as Ngumalo put it. Why was that not done then? Why was there not even a mention of this? Nobody knows about it until now. There wasn't a mention of this, and by until now, I mean a few weeks ago, when he first brought it up in court that, my lord, we want to play a video in court. You know what I mean? But before that, the defense was not aware of all this dun drama. It is disappointing, but that is a confession, in my opinion. Is it a coincidence? From where I'm sitting, no, it's not a coincidence. If he had said November, would have been like, okay, they were working on it. December? After Ngomezulu had passed away? Too convenient, if you ask me. Too convenient. Don't forget, Keninda himself told us before Ngomezulu passed away that he's been running around going to the Rand Hospital and he can't find any information. Do you guys remember that? It's not me who said it. Brigadier said it himself. You see, they have a tendency on telling on themselves. The sad part is my lord doesn't pick up. Or is it that he's not picking up, or he just ignores it? He has an agenda. Let me know your thoughts in the comment section. Do you think it's a coincidence that Baloyi submitted this subpoena to ENCA video Dun only in December? Okay, let me know your thoughts in the comment section down below, but let's continue listening on.
As far as the submissions of Advocate Nisi's are concerned, I think we did indicate, my lord, that we're not really pursuing the issue of the dentist any further. I thought the matter will then be left at that. But he also, with the greatest respect, my lord, submitted there was also this obfuscation between relevance and the weight to be attached to the evidence. And I think, with the greatest of respect, Advocate Nisi was arguing the weight that should be attached to the evidence. He mentioned that Mr. Bailey states in the affidavit that he bears no knowledge of the events. He was in China, but it's not about that, my lord. It's about the authenticity and reliability of the footage And that's where Mr. Bailey comes in.
Sorry, is he the person in charge?
He's the news editor.
The news editor.
Yeah, he's the news editor at ENCA, under whose custody the material is archived. And again, to deal with the issue that was raised by Mr. Ramusipil, as well as Advocate Nisi, about the fact that this evidence that can be of no assistance to the court, except if Mr. Longwe is called. Well, two submissions in this regard. Firstly, a matter is decided on direct evidence or also on circumstantial evidence. And there's nothing that debars Brigadier Gininda if he can identify a person on a video to state as to who that person is. We've just been through that exercise, my lord, with the photos, where the witness would look at the photo and state what they can observe on the photos. That's perfectly permissible, my lord. But as to the question as to why the state is not calling Mr. Longwe, my lord, the state doesn't have to call every witness whose name appears on the on the list. If at the conclusion of the state case a witness is not called, it's up to the defense to call that witness. We therefore submit, my lord, that the footage is relevant, and we have sketched the background as to why it is relevant, the proposition that was made by Mr. Mngumezulu, and that it should therefore be admitted as evidence at this point, subject to the proviso that we've mentioned in subsection 3 of the Evidence Act, my lord. This is as far as we can take our submissions, my lord.
Yeah, but just for fulsomeness, the court has still got to decide, I'm with you, to decide whether it is in the interest of justice. Is that not a supervening ratio in the
Yes,
in
well,
section 3?
Yes, well, if for whatever reason that witness is not available, the court then can, in the interest of justice, decide to admit such evidence.
But still, the defense can argue that that evidence is prejudicial or it is not in the interest of justice. Is that not so?
Well, they can do that.
Yeah, fine.
But that will be at the end.
That's it.
Yeah, at the end of the case,
Yeah.
about the weight that should be attached to the
Yeah, fine.
evidence. But at this point, the question is the evidence relevant?
And as far as Longwe is concerned, if the state doesn't call him,
Well,
the law says you must advise the state,
the defense, yes.
that you're not going to call him, and then the defense can use him if they
Yes.
want to.
Yes, indeed, my lord. That is the legal position.
Yeah, but my interest, okay, fine. Are you through?
Yes.
So after all the submissions from Ngumalo, Rams, Nisi, all the judge is picking up on is, oh yeah, so if the state doesn't use the witness, in this case Longwe, is made available to the defense. So basically the judge is saying, so what's the big deal? What are you crying about? Stop crying, because you'll still have access to Longwe. And then now, is this not something that the defense can argue? Can you see where the judge is going? that this is a prejudice. Can they not argue that? Because as relevant, you could just tell the judge was so dismissive of the defense. And I can at the same time also understand why Nxumalo sometimes doesn't participate. It's for reasons like this. You put in all the work, you put in all the submissions, you put in all the hard work, and the judge just comes back and is dismissive rather, not submissive, but dismissive. Let me know your thoughts in the comment section down below. In the next video, we will cover, according to the judge, a crucial mistake that Umnisi did, which is more important than this whole video debacle that was going on because the judge wanted to get through to this next part. Thanks for watching. I'll catch you on my next upload. Bye.